the relationship between the state and the union will now be governed by the provisions of the Indian Constitution, which means that we don't have anything more. We are governed by the Constitution of India. We have also looked into it. There were 4 representatives from the state of Jammu and Kashmir earlier in the Constituent Assembly. We have gone through each clause, and we have ultimately looked at 370 also, which is an integral part of the Constitution, which is also a part of the Constitution. And we have therefore decided that we will abide by this. Now, my lords, the question of if this is the integration, therefore becomes complete, my lord, on enforcement of the Constitution. There is nothing residuary. Now, if your lordships kindly have a look at, my lord, I am sorry, but then to make my submission, my lord, on the question of, my lord, what therefore survives under 3, what therefore survives, my lord, will also have to be looked into in Article 370 and 373, and there is nothing more, my lord, which can be read into it. There is nothing in the Constitution of India, my lord, which carves out an exception in the case of state of Jammu and Kashmir, both as regards the sovereignty, any sovereignty, other than, my lord, Article 370 itself. And 370, in my respectful submission, does not indicate that there is any residuary sovereignty that is left with the state of Jammu and Kashmir. It becomes a part of the Union of India. My lord, the enforcement of Article 370 also and powers exercised by the President from time to time in issuing a constitutional order is also an exercise of a power that is conferred, my lord, under the Constitution of India. It is nowhere else. The President doesn't go outside the bounds of the Constitution. And therefore, my lord, if abrogation of 370, which would result, my lord, in the effacement of any special status that is given to the state of Jammu and Kashmir, is inbuilt into Article 370, and it is also within the knowledge of, my lord, the sovereign in the state of Jammu and Kashmir, my lord, prior to the enforcement of the Constitution, to say that I still retain some residuary sovereignty with me in spite of the enforcement of the Constitution after 26/1/1950, not reflected in Article 370, not reflected in any other provision of the Constitution of India. My lord, it's not a submission that would be countenanced by your lordships. But what are the petitioners asking for? Petitioners, my lord, say that 370, which is a temporary provision, must be treated as a permanent part of the Constitution. What for? If, my lords, is it for the purpose of, my lord, claiming for expansion of any right? Apparently not. No, my lord, because once the 370 goes, and, my lord, Jammu and Kashmir, my lord, therefore, the integration is complete even when the enforcement of the Constitution takes place. My lord, the insignia of any sovereignty is a lawmaking power. One of the insignia is a lawmaking power. That's, my lord, the lawmaking power, my lord, has been with the union and with the states, my lord, in list 2 and list 3 also. Unless, my lord, the parliament by resort to the provisions, my lord, of lawmaking power in the list 3 also supersedes the legislation that is prevailing in the state. If, my lord, it completely therefore applies after Article 370 is abrogated, isn't there an expansion of the right, my lord, that is available to any person who says that I am a resident in the state of Jammu and Kashmir, I therefore belong to that state, I also belong to the Union of India, but therefore, my lord, what is the abridgment of the right, my lord, that the petitioners are really concerned about? No, my lords, insofar as abrogation of 370 is concerned, when the lordships would have noted that subarticle 3 was also therefore part of, my lord, in the manner in which it was framed even before 1950. I mean, on 26/1/1950, my lord, this is how it looked at. And that was at a point of time when the Constituent Assembly for the state was yet to be convened. It was convened later, my lord, in January 1951. Now, if your lordships kindly come to that for a moment. There are 2 places, my lord, where the Constituent Assembly for the state is referred to. Firstly, my lord, in subarticle 2, but please come to subarticle 3. Notwithstanding anything in the foregoing provisions of this article, the President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify. Proviso. provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such a notification. My lord, the crucial words are recommendation of the Constituent Assembly of the state referred to in clause 2. My lord, in clause 2, the reference to the Constituent Assembly is qualified by certain words, my lord. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in the second proviso to subclause D of that clause be given before the Constituent Assembly, my lord, please permit me to read it slowly, for the purpose of framing the constitution of the state is convened. Therefore, my lord, it was understood that a Constituent Assembly will be convened for the purpose of framing the Constitution of India as originally contemplated in Article 370 itself. But this Constituent Assembly is only for the purpose of framing the Constitution of the state. And, my lord, it is a fact which is accomplished that on framing the Constitution for the state, my lord, it dissolved itself. That it will be convened for a specific purpose and that it will dissolve itself were also matters within the knowledge of the framers of the Constitution even then. And then, my lord, therefore, in proviso, when they refer to the Constituent Assembly for the state, there was a terminus acquo, my lord, for the Constituent Assembly, which was within the knowledge, my lord, of the framers, and therefore that is what is referred to in the proviso. My lord, it could not have been contemplated that the Constituent, it was, or rather, my lord, let me put it this way. It was, my lord, it was concluded, or it was definitely, my lord, the intention that the Constituent Assembly for the state, which is convened for the purpose of framing the constitution of the state, will have a natural death, my lord, when the constitution for the state is framed. But when they say, my lord, that the recommendation of the Constituent Assembly for the state shall be necessary before the President issues such a notification, did they not have in mind that the recommendatory powers are therefore coterminous with the tenure of the Constituent Assembly, which has to end, my lord, with the framing of the Constitution for the state? It is not as if, my lord, the Constitution contemplates a Constituent Assembly for any purpose other than the framing of the Constitution for the state as such. Therefore, my lord, see, one of the termini which your lordships were referring to, there are two terminus acquo, my lord, insofar as the Constituent Assembly is concerned, going by subarticle 2 and the proviso. One is the convening of the Constituent Assembly, and the other is the dissolution of the Constituent Assembly. The proviso merely does not say Constituent Assembly of the state. It says Constituent Assembly of the state referred to in clause 2.